You're listening to Clause 8, the voice of IP. Today's episode, John Lee.
The way to think about it is not really about, is it going to get past this Congress or not? I think the way to think about it is substantial progress made this Congress or not? Right? So if at the end of this Congress, both the House and the Senate have PTAB reform bills, neither of them gets passed, but they were introduced, they were changed, and they got, substantially closer together in terms of what's in them. I think that's great progress. That shows it's headed in the right direction, and it's got a good chance of eventually happening.
After you're finished listening to this episode, don't forget that we have a full archive of previous episodes in your favorite podcatcher. And when you're there tapping around, don't forget to leave a 5-star rating. And hey, tell your friends all about this great show. And now here's your host, Eli Mazur.
Today we're lucky to be joined by John Lee. He's now the Chief Counsel for IP in the U.S. House of Representatives on the subcommittee that handles IP. Prior to that, he served as a lead judge at the PTAB. John, thank you so much for joining Clause 8.
Well, thank you, Eli, for having me.
So I had the honor of moderating a panel with you at IP Watchdog Live. And as you started talking about a possible solution to finally get some kind of fix for Section 101 passed, at that moment I said, I got to have John on Clause 8. So thank you so much for coming on Clause 8.
Man, if moderating that counts as an honor, you really need to get out more. But I'm happy to be here.
Thanks. All right, so I guess I wanted to kind of start with, do you remember when you first became aware of patents, and what was your impression of the role of patents when you became aware of them?
So I would say probably the first time I became aware of patents was in college. I was at the University of Pennsylvania as a child of Korean immigrants. I mean, I guess technically I'm an immigrant also, but as a child of Korean immigrants, predictably I was pre-med. So patents and IP law in general, what it signified to me was a chance to save myself from the ignominy of complete failure in the eyes of my parents. I don't know, it was pretty close to complete failure, but I wasn't doing so well in school in my pre-med track, and my best friend, who is currently an IP lawyer, he's a copyright lawyer. He was a couple years older. He had already graduated. He was at BU Law School, and he said, John, you should take a look at IP law. I was like, oh, yeah, sure. What the heck is that? He's like, yeah, there's patents, there's copyrights, but patents, that's, you're an engineer. I mean, a bad one, but, you're an engineer. And, here's I know you'd be good at law, so check that out. And so that's when I first looked at it. And, I guess the rest is history.
Do you remember if you had any notion about what are these patents for, or?
Well, I read quite a bit about it, actually, and I ended up doing a senior project of some kind. I forget exactly what it was, but it had to do with patents and something to do with patents. I can't remember. So I did do quite a bit of research about it, but, basically it was, a chance to go to law school and do something where, all the time and energy I had spent the first part of my life on technology and science, didn't go to waste. In fact, it was very relevant. That was great to me.
So it's interesting you did it. You said you did some senior project. Do you remember if you thought patents are a good thing, a bad thing? They help with innovation? They're just something you hang on the wall? Any kind of notions like that?
I guess I didn't really ascribe a value judgment to them. I mean, I was coming from the world of research science.
Okay.
So it certainly wasn't a negative connotation. It was a positive connotation. But I didn't really think too deeply about whether they were a good thing or a bad thing. They were a thing. A lot of my bosses, the PIs, had patents. So to me, they were like, okay, so you become a scientist and you discover cool stuff, and then you get patents. Great.
Now you're one of a handful of people, I guess, in Congress who focuses on IP issues. Can you tell us, how did you end up in that role with the title of Chief Counsel for IP?
Yeah, so it's kind of a tortured path, I guess you could call it. So Rewind way back to 2017. At the time, I was at PTAB, and the House was looking for a detailee from the PTO. The guy who had my job at the time was Joe Keeley. He was the Chief Counsel for IP at the time. And he had his colleague, Vishal Amin, leave to become the IP enforcement coordinator. So he was just him, and he needed help. So he asked the agency for help, partly because at the time, Michelle Lee had stepped down as PTO director, and the acting director was from the Hill. It was Joe Mattal at the time. And Joe knew each other, so he asked Joe Mattal for a detailee. And Joe went to Jamie Simpson, who at the time was a detailee for Senator Coons, and asked her for a recommendation. And I guess, I had sucked up to Jamie. No, Jamie and I go way back. She's brilliant. And so she, suggested.
Look what you're on. No, I'm just kidding.
and she suggested that he ask me. So, picture this: like I'm kind of, I don't think I was a lead APJ yet at the time, so I was just kind of a peon APJ, if you want to call it that. I had just introduced him, Joe Mattal, the acting director of the agency, at this conference, and I didn't know him from Adam. I was just, the guy selected to read a piece of paper. And then right after he gave his remarks, he comes and makes a beeline for me, right past like the chief judge and the vice chiefs. And they're like, what the heck is going on? Why is he going over to talk to John Lee of all people? And he sits down. He's like, hey, would you like to go to Congress on detail and help advise them on IP law issues?
Yeah.
Does that sound interesting to you? And I'm just like getting over the fact that the director of the agency is talking to me and knows my name. And I said, sure. And then within like a couple months, I was there. So that's how I got to Congress. And I was actually on detail for a year. And then the Republicans lost the majority in 2018. And so I returned to PTAB. And then a number of years later, some people I'd worked with while I was there for the first time, they were involved in selecting, another counsel to handle IP matters. And so they asked me to come back. And so I went back in 2020, right about the time when Mr. Jordan took over as the ranking member of the committee. And just this past year,
Judiciary Committee.
Yeah, of the Judiciary Committee. And then, so I was on detail from 2020 up until earlier this year when we retook the majority. And that's when I, made the permanent switch.
And what does your role involve? What is the Chief Counsel for IP in the House?
Sure. So the House Judiciary Committee has 6 subcommittees, and one of them is the Subcommittee on Courts, Intellectual Property, and the Internet. Each subcommittee has a Chief Counsel, and so I'm the Chief Counsel for that subcommittee. And all intellectual property matters coming before the House of Representatives goes to the Judiciary Committee, and on the Judiciary Committee it goes to the IP subcommittee. And so I'm kind of ostensibly in charge of that committee, working for, of course, the chairman, Mr. Jordan, and for the subcommittee chairman, Mr. Issa.
Darrell Issa is the chairman of that subcommittee. Is that, and obviously each congressman has slightly different views and all that. When you do your job, are you representing all the Republicans on that? Are you, I guess, are they all your bosses? Or is Darrell Issa kind of really the one, your boss?
Yeah, so, this is one of those questions that I get a lot. And I think, before I had gone to the Hill, I probably would have asked a similar question.
Yeah.
It's particularly in the House, having these sort of situations where, so of course the full committee chairman handles all the hiring of staff for the committee, and this includes all the subcommittees. So my boss formally is Jim Jordan. But Mr. Jordan's leadership style, generally speaking, is he pays a lot of attention to what his subcommittee chairmen do and say and think about their relative, areas of responsibility. So, in this case, it'd be Mr. Issa. And so I work quite a bit with Mr. Issa primarily because he's the subcommittee chairman and he kind of sets the agenda for the subcommittee.
So you mentioned how you kind of randomly ended up on the Hill. It's not something it seems you dreamed about.
Yeah.
Not
Thought about it for a minute before it happened.
No, you went to patents, but a lot of people, I guess, in this town are thinking about these issues and about what's happening on the Hill. With these issues, that's their job. What was it like stepping into that role?
Yeah, so it was very interesting. Not at all what I expected. I'll be honest with you. So I show up, and the very first thing that Joe Keeley tells me, he says, "Okay, John, welcome to the House of Representatives. Next week we're having a hearing on patents and Native American tribal sovereign immunity. It's your hearing. Go."
Yeah,
and I was like, "Oh, okay."
And so who was the subcommittee chair at that?
So at that time, it was also Darrell Issa.
Okay.
He actually left Congress after that term for a couple years. But yeah, no, he was the subcommittee chairman at the time. And, I'm sure at least some of your listeners will remember Allergan in a bid to avoid PTAB review of their patents. They assigned their patents to the St. Regis Mohawk tribe. Very clever. Yeah, and they thought it was clever. And the tribe claimed that they couldn't be subjected to PTAB review because of tribal sovereign immunity. That is later, the courts have thrown that theory out the window. But at the time, it was, blew everyone's minds.
Yeah.
Everyone was going nuts about that. So I spent a whole bunch of time learning about, not about patents, not about IP, but about tribal sovereign immunity, and talking to all sorts of experts about that to set up that hearing. So that was my first experience. But yeah, no, after that, obviously everyone wants to know who the new kid on the block is. That's true of everyone on committee staff.
Anything from that time who was able to make a good impression?
Yeah, you want to know who made the worst impression. My God,
if you want to tell, feel free. But.
No, I won't do that. No, I mean, I think pretty much everyone makes a good impression. They pay a lot of money to lobbyists to make sure that happens, I suppose. I will say that I was probably different than most staffers they were used to. Reason being that, I had a over a decade-long career in IP law before I got there.
Yeah.
And that's not, typical. So, a lot of the early meetings had to do with, people trying to explain to me what a patent was, or, there's this patent office. I'm like, oh, really?
They didn't bother looking in your bio, or
some did, some didn't. I didn't hold it against anyone. Although,
or your prior job, for that matter.
Yeah. Although I did have an experience much later. I think I told you this, but I did have experience much later when someone came in to complain about a PTAB decision that I had actually drafted, and complaining about how the panel was out to lunch. I'm like, interesting. I don't think they realized that.
So you were able to confirm his story.
But no, yeah, and I think some of the differences were, I was much more. Obviously, I knew all the background stuff, but I think something that happens a lot on the Hill is that there are a lot of people focus on narratives, right? What is the story you want to tell, right? Who's the sort of the underdog being harmed here? Who's being hurt? Which jobs are being lost? Which communities are being affected? That sort of thing. And, I both from coming from a technical background and from the background of, like a litigator who was always, like, what can I prove? What evidence do I have? And then, obviously, from a judging background, I was like, oh, you say that. So, what data do you have for that? Right. Yeah, you've pointed out these two people being hurt. Like, how widespread a problem is this? And I think that took a bunch of people kind of aback. They weren't used to that kind of conversation. And I would say, probably 95% of times where I'm like, yeah, I'd love to get some data on that. They're like, yeah, sure, we'll get back to you. And I get nothing. I'd get no data. So, So that was a little frustrating. But I think people have gotten used to me now. People have started showing up with things.
But anything stand out about what somebody did that did make a good impression instead of did anybody come in with data?
Yeah, I mean, I can't think of anything off the top of my head that's like particularly noteworthy. I did, I did run into people, that I had known in other areas, and neither of us knew that we were suddenly in the policy space. So that was kind of interesting sometimes. But nothing comes to mind. But I think a lot of people did a pretty good job.
So, you mentioned you had a long career before you even got to be PTAB. Like after your bad grades in pre-med, you did pretty well. You started at Kirkland & Ellis, which is obviously, I think the biggest firm, but also has a very good reputation for patent litigation. And I think primarily they represent on the defense side around 2005. I think you started there. And, that was the beginning of that, I think, the rise of the patent troll narrative and kind of efforts to counteract that. And up to this point, what do you think, what is your impression of the trajectory of the patent system over that time since you started?
Yeah, I mean, this is something I hear about a lot on the Hill. And, it's part of the narratives that people have. And if you listen to some people, America's patent system is like going in the toilets. It's been in like steady decline for decades. And, we're like ranked 12th or something on the chamber's ranking, and isn't this terrible? And then other people will tell you, no.
They actually, US went up under Yanko, but I don't know.
And other people will tell you, oh, no.
But that's also the data you like.
Well, so I actually looked into those rankings. I looked into those rankings, and I actually called Gipsy at the time because I'd been told this. I think when I first got to the Hill, that was when we had first slipped from like 2nd to 6th or something like that. And so I asked about it. I'm like, so how do you come up with these rankings?
And sorry, you called
the chamber.
Oh, yeah, okay, yeah. Oh, Gipsy is.
Yeah. And I was like, so how do you come up with these? And they're like, we look at a variety of things, and then we kind of have an index between, I forget what they said, like 1 and 4 or something for these like 4 different categories, and then we average them. I'm like, okay, so how do you come up with the index? And they're like, we just take a look at things, and then we assign a number. And it's like completely arbitrary. And I'm not saying that they're not trying to do a good job, and I'm sure they are, and I understand what they're trying to do, but it's not like data driven.
No, it's funny because I guess your answer about you want to see data is actually a pretty common answer that I get from former or current staffers on the Hill. But when I hear that, I'm like, anybody can get any data they want, because I see all these groups commissioning studies, and then when I talk to them, they cite that study. But
when I get data, to the extent I get it, I look into it. Right. So a lot of people, for example, sent me the chamber rankings as data. And I was like, that's not what I mean by data. I want to know, like, how many times does this happen? And,
But that's actually a data piece of its own, right? If a chamber thinks the IP system is not doing well.
Different aspects of the economy, different industries have different views on that because, in all honesty, it's an extremely complicated question. Right, because patents, and that's just patents, right? I mean, other forms of IP become involved as well, including for the same things like trade secret protection. But patents serve different functions for different industries, and they're treated differently, they're transacted differently. The way patents interact with the electronics industry or the semiconductor industry is very different than how it interacts with the pharmaceutical industry, or the automotive industry nowadays, things like that. So I think it's simplistic to say that the patent system is definitely trending one way or the other. I think that unquestionably there have been massive changes in the past, say, 20 years, and it's changing things up quite a bit. Whether that's net positive, net negative, I don't know how useful a narrative that is. I will say, though, that the one thing that I think, I was about to say everyone, but not everyone agrees on anything on the Hill. So what I think most people will agree with is that, without a doubt, whether it's trending up or trending down in the aggregate, it's certainly changing a lot and changing often. And that makes it really hard to make decisions, whether it's about where you're going to invest your R&D budget, or whether you want to invest in that company and based on their IP portfolio, or any of these decisions. It makes it really, really hard, and that's not really good for anyone. So I think that certainly is an issue.
You actually also clerked for Chief Judge Michel, who was the first guest on the Clause A podcast. And I was talking to somebody from a different country who started listening to my podcast, and they listened to the Judge Michel episode, and they said, wow, are things really as bad in America as Judge Michel says? And how did you...
Was he talking about patents or something else?
Patents, yeah. I guess the patent system. You clerked for him. I guess, why do you think, after basically devoting his life to IP, why is he so... Maybe you could answer it more broadly, why are people like Judge Michel so worried about the state of America's patent system?
Yeah, no, I mean, I certainly can't. I wouldn't presume to speak for him. He does a fantastic job of speaking for himself. I think that much is clear. That's always been true. And clerking for him was an amazing experience. I think about him essentially as a second dad. He's been such an important influence on my life. And I respect, obviously he has a lot more experience than I do. A much longer career in this space than I had. Although he didn't originally dedicate himself to IP law. That didn't start until he joined the federal circuit. Before that, he was a Senate staffer and he was a district attorney. So, but I obviously, even with his late start, he has a lot of years on me. That said, I think that like anyone else, he, both from his background and from people he respects the most when it comes to intellectual property issues, he's developed a particular opinion about what aspects of the trends in patent law are more important than others, and that's sort of the view he has. I don't share personally all of his views about that, but that's okay.
From where you sit, hearing all these different opinions, anything that stands out to you about what is driving the big divide and impression of what is the patent system doing well or badly? Is it?
Well, it's money, is what it is. I mean, let's be honest. At the end of the day, it's money. The amount of money at stake, the amount of money that turns on these questions of patent law has, skyrocketed in the past few decades, right? The amount of money that can be won or lost in a lawsuit, the amount of money that needs to be paid in royalty payments for, a standard essential patent, the amount of, amount of sales that are subject to patent protection that are at risk to an ITC exclusion order. All these things, the amounts have gone up and up and up. And so people care a lot more about it. The companies do anyway. The amount or the importance of technology, particularly, cutting edge technology to our economy has gone up as well, right? And the importance of technology leadership geopolitically has also gone up. So that puts intellectual property and intellectual property protection front and center more often with higher stakes. So, of course, people with particular places in that ecosystem, if you're a defendant all the time, you're going to have a very, a particular view. It's going to be different than if you're a plaintiff all the time. And the higher the stakes are, the more you're going to care about your view. So I think that's led to a lot of polarization.
I want to talk about maybe things that possibly transcend money, but you'll let me know if they do or not. Some of the recent actions by the administration. Most recently, they announced that for the first time ever since the Bay-Dole Act was passed, they're going to exercise marching rights for drug patents based on pricing. What was your reaction to that, and any other thoughts you have?
Sure. So I will say, not that I'm defending the administration. I'm not going to do that. But just to clarify, so they've put out a framework of how they're going to make this decision about marching rights, and the framework is up for comment. It hasn't been enacted yet, right? So people can file comments. And for anyone out there who feels very strongly about this, you absolutely have a chance right now to lodge official comments about how much you love or hate. I'll emphasize the hate. This framework. You have that opportunity right now. So run, don't walk, to go do that. Now, one of the factors, not the only factor, but one of the factors, and as you said, an unprecedented factor is to basically regulate price of things. And again, that's another popular misconception about this. It's not actually limited to pharmaceutical drugs. They could decide that, by gosh, the cost of roof tiles is way too high. We're going to march in on, I don't know how many patents there are on roof tiles, but you know what I mean. Patents on quantum computers. Boy, quantum computing prices are too high for this government, our liking. So we're going to march in and take some, all that is possible.
Or for smartphones,
Yeah, anything. Smartphones, anything.
In Colombia, somebody, I guess smartphones are a human right or something like that. So.
Well, hey, I mean, if you ask my teenage son, he would agree. So I mean, again, speaking just personally, I find that very concerning. That's, quite an ambitious role for government in our economy. And, I think, the polls show a lot of Americans agree with me that the government, in terms of regulating the economy has not been doing a great job lately, and you can kind of see what the shortcomings are. So yeah, no, I personally have a lot of concerns about it. Now, of course, my personal views aren't the most important. Of course, it's the members of Congress, and I'm sure that various members of Congress are going to chime in about this. But yeah, no, it's certainly particularly when you consider that this is coming out of the Bay-Dole Act that's birched by Bob Dole, and before I actually don't know if Birch Bayh is alive or not. That's bad. But obviously Bob Dole has passed on. But, both senators have made clear that this type of thing is absolutely not what they had in mind when they wrote in those rights when they authored the bill. You would think that they would have an authoritative view on that. But, hey, this is where we are. And, like I said, there's still comment period open and it's not finalized. So we'll see what happens.
The reason this proposal happened, it stems from, I guess, a lot of criticism about the cost of drugs.
Mm-hmm.
And earlier this year, there were even GOP congressmen, I guess, which is the change, right? Which were kind of also kind of decrying the cost of drugs, and about some even wrote a letter to Director Vidal, including Darrell Issa, saying, let's figure out a way for these drug companies to stop getting all these patents so they can make drugs expensive. And, the administration finally does something about it. Maybe I missed it, but I haven't really actually heard that much reaction from the Hill as I thought I would about this proposal. Maybe it's just the timing of it and with everything else going on. But is it like, be careful what you wish for? Is it kind of like everybody was pushing for this and the administration does this? What are your thoughts about that?
Well, I mean, if that's really the logic that this administration is taking, man, we got bigger problems. I mean, the fact that, I think obviously there's broad-based concern about the cost of healthcare in this country. That's not a Republican thing or a Democrat thing. I think everyone's concerned about that. Everyday Americans are concerned about that. Now, being concerned about the cost of healthcare does not mean, hey, let's use the Bay-Dole Act to march in and take away patents.
Yeah.
Or not take them away, but, compulsorily license them. That's not necessarily what that means. I'm sure, Bernie Sanders thinks that, but many others don't.
Yeah.
It's kind of like saying, "Oh, I think there's a problem with referees in the NFL, let's get rid of the NFL."
Yeah. Bernie Sanders publicly says we should get rid of the patent system for drugs and use some kind of prizes or something like that.
Yeah.
But there has been a lot of noise about drug companies manipulating the patent system.
Sure.
Yeah.
Yeah. No, I think that there is quite a bit of attention on exactly how the pharmaceutical industry, writ large, uses patents in their business. Now, obviously, none of this is new, right? This is the way they've gone about their business mostly for many, many years. Now, I think scrutiny is totally fair, right? There's nothing wrong with Congress or anyone else taking a look at that. And obviously, there have been a bunch of studies done about it and all kinds of advocacy. And the New York Times wrote this article, and I know various commentators like Adam Mossoff have sounded off about how screwy that was, and so there's a lot of attention to it, and I think that's totally fair. But that doesn't mean that that means that everyone is okay who has expressed a concern is okay with any way we see fit to address that problem. I think I personally am concerned about the high cost of healthcare. That doesn't mean I think marching in and taking away drug patents or taking away exclusive rights over drug patents is the way to go.
So I guess it's fair to say that the administration didn't build consensus over this proposal, as far as you know, on the Hill.
No, yes, I think that's very, very fair. I think even they would have to admit that was very, very fair. And if they don't admit that, they will after they get, the 17,000 comments they're about to get.
This wasn't, I guess, the first unprecedented action by this administration. They kind of started out during the COVID-19 pandemic, I guess, was still ongoing. And they, maybe some weren't surprised, but I guess a lot of people were surprised that they backed waiving IP rights. You actually did a hearing about that, kind of the problems with that. And some thought that's just a one-time thing. That's just pandemic. They don't really mean what they say. Putting these two things together now, does that say something new about where this administration stands on IP rights overall?
Yeah, it's an interesting question. They certainly have done a number of things that folks in the what some would call the pro-patent community would find concerning, right? Because certainly there's the Bay-Dole situation, as you point out. There's the situation with the WTO and the waiver of the TRIPS treaty protections when it comes to intellectual property on COVID vaccines. They've been talking about expanding that waiver to additional COVID-related technologies. The Director General of the WTO has talked about expanding it to all kinds of technologies, right? Climate-related technologies, whatever the heck that means. She thinks that'd be great to do the same thing. And we don't know how the Biden administration will react to that. But so far, they haven't put up really any resistance to any of these things. There's been rumors about the United States brokering a treaty with the WHO and building in an IP waiver into that treaty as well, as a way to deal with any future pandemic of any kind. I don't know how much truth there is to those, but there does seem to be some smoke, and maybe where there's smoke, there's fire. There's also what happened with the Trump administration, the Department of Justice under the Trump administration had a particular policy when it comes to standard essential patents and antitrust. That policy was different than the Obama administration's policy. And then Biden came in, they rescinded that policy. There was a whole bunch of, discussion about it. And then now we have no policy of any kind. And we don't know what they're going to do with that. Maybe nothing, but maybe something.
The hope from the pro-patent community was that was the new policy, that they have no policy. But I guess you're saying that.
Well, I think the pro-patent community quite liked the Trump administration version. That was rescinded. It wasn't replaced by, say, the Obama version, which I think they did not like. But it wasn't replaced by anything. So we just have, again, back again to what we talked about earlier, just a whole bunch of uncertainty about IP rights. That's not good for anyone.
I guess you're saying there's if there's empty white space for regulation or some kind of statement, there's government officials itching to fill that, or is that your sense?
I mean, I wish they would say, we are not going to issue a policy. That's what we want to do.
And they haven't.
They haven't said that either. So yeah, so no, I certainly can see why the quote unquote pro patent community has concerns about the Biden administration.
I was actually looking at the takeaways from that hearing about the waiving of the IP rights. You're all putting them together, but two things I guess stood out to me, which I think were very eloquent. One was you said IP protections are vital to incentivize the innovation that makes the United States the world leader in developing advanced vaccines, therapeutics, diagnostics, and other biotechnology. And then the second one that stood out to me, it says the Chinese Communist Party has targeted U.S. biotechnology preeminence, and this would be kind of a way to help them with that. And I thought that's very compelling. But don't these takeaways also apply to other technology areas? AI, on top of mind, or
absolutely, no, it absolutely does. There are, well, I mean, if it were up to the Chinese Communist Party, they would replace the United States as the world technological leader in every technology if they possibly could. They've been very, very open about which ones they're targeting. They publish this stuff. It's not even, we don't even need the CIA to find that out. They just tell you, we intend to supplant you in these areas. So, we know that that's what they want to do. I just don't understand why the United States would kind of make it easier for them to do that, because that's not good for Americans. So, just my personal view, I think that this is a huge issue. Maybe isn't getting the amount of airplay that it should, because you're right. It's not limited to just, what's happening with the IP waiver. Number one, the IP waiver playbook could be applied to other technologies, as the WTO would love to do, it sounds like. But yeah, no, it applies across other things. For decades, we've had a number of hearings on this about how the Chinese Communist Party and the Chinese government has been engaging in theft of American intellectual property, American technology from U.S. firms. And, not enough has been done to stop that, punish that, counteract that. So that's another one. There are all sorts of ways. That's one thing. I'm not trying to demonize the Chinese, the Chinese, because, number one, I'm not demonizing the Chinese people, of course, but, China's doing what's best for China. Of course they will, right? So I'm not, they're evil people because they're trying to do what's best for China. Of course they will, right? That's their job.
Yeah. Well, I think the Chinese Communist Party is evil, but
that's a different issue. The way they're approaching competition with the United States, they're doing things that are in their best interests. I think some of it's underhanded, and I agree with you that, of course, the Chinese Communist Party is not, a fabulous thing. But, they're doing what we should expect them to do, I guess is really what I'm saying, right? Of course they're going to do this stuff, right? So why wouldn't we, A, know that's going on, expect that it's going on, and then do something about it to protect our leadership in technology? I think we should.
Somebody might be hearing you say that and say, well, all right, I'm glad, John agrees that waiving IP rights is bad, and that, Darrell Issa had this bill about that and hearing. But, the administration is also doing other things to disincentivize innovation. The PTAB is invalidating patents related to AI and all that of U.S. inventors. The state of the Section 101, it's unclear to many whether what's patentable or not. And that's going to disincentivize investments in those areas and so forth. Do you have concerns that, besides this IP waiver, IP system being weak in these other ways that I mentioned are doing the same things?
Well, so, I can't, to be fair, I can't really blame the state of 101 law on the Biden administration. That was the Supreme Court.
Yeah.
But
I'm just thinking, are those concerns
the
same in those areas?
Yeah. Yeah, this is similar to what we kind of touched on earlier. Of course, I am, to the extent that there is a decrease or a disincentive to invest in research and development and innovation in the United States, I hope that concerns everyone, all Americans. Now, is that actually the case, and how much is that the case? I've seen varying data on that, right? Some data shows that R&D expenditures have been rising. Now, is that definitive? I don't know. Maybe it would have risen more than it is rising now if certain things were different. I don't know. It's not as far as the data I've seen. It's not like completely clear cut that that's the case. But putting that to one side, how do you increase incentives for innovation, and how do you reduce disincentives for innovation? And I think, regardless of what the current state of play is, those are laudable goals. I think that for some of these things that have been suggested as sort of causally linked to, say, disincentivizing innovation, I haven't seen the data to support that. So, for example, when it comes to the PTAB, the data that I've seen, and I haven't seen data otherwise, but the data that I've seen is that, when you take you could do it on a patent by patent basis. You could even do it on a patent by patent claim basis, as well as on a petition by petition basis, that the rate of invalidations in a PTAB proceeding is actually slightly lower than historically in district court in patent cases when it comes to validity determinations. So if you look at that data, why would PTAB be a disincentive? Why would that disincentivize innovation? It shouldn't. Now, I mean, of course, when I'm making, if I'm at a company and I'm, the chief technology officer or whatever, and I'm trying to decide where to spend my technology budget and my R&D budget, maybe, I don't know that data and I'm looking at atmospherics or something like that. I mean, I don't know. But, looking at data, like what is the real effect of PTAB on the corpus of active patents out there compared to the alternative, which of course is traditional district court adjudication. I haven't seen data to show that it's appreciably different in terms of the rate of invalidations. And they've also, the PTO has also put out studies that looked at the the biotech industry in particular. And also there, it didn't, at least that data didn't seem to show any, negative impact comparative to, traditional adjudication of PTAB. So, I don't know that if you want to, again, go after this goal of improving incentives for innovation and reducing disincentives, I don't know that PTAB is really where the action is. That'll make the most impact, I guess is what I'm saying.
The other day I was reading an article about, I guess, the dispute between Apple and Optimism, and Professor Colleen Chen was quoted in it. She's advised Obama and the Biden administration on IP issues. I think it'd be fair to say she's associated with being somewhat skeptical of patents. I don't know if she would agree with this characterization, but that's my read. But she said something that kind of, I was like surprised. She said, this was like an article for entrepreneurs. And she said, if you can keep a secret, keep it secret. And only if you can't keep it secret, that's when you should possibly consider using the patent system. And I'm like, this is actually the same kind of advice that you hear from those who are saying, the patent system is falling apart and blah, blah, blah. And she's actually saying the same exact thing, that the patent system is kind of at a state right now where, you shouldn't really trust it unless you have no other options. Is it even? And I know you like data and everything, but this seems to be the consensus right now about the patent system. Maybe it has no impact on R&D and innovation. That's another story. But I guess, what are your thoughts?
Well, I don't know that that's the consensus. It's not like patent application rates have fallen at all. But what I've certainly heard that, and I mean, I don't know Professor Chen all that well, but I don't know the context Colleen was making her comments in. I would disagree with that, right? I mean, I don't know if from a particular potential patent applicant's point of view, maybe that's true or maybe that's not. I don't know. Depends on the circumstances. But from a systemic point of view, from the point of view of the country at large, the American citizenry, American industry in general, of course, it's bad. It's bad for innovation. Because one of the main benefits of the patent system and getting people to engage in it is that not only do you give them, of course, limited protection for their innovations, but you get information out there into the public about what the inventions are, and that can inspire follow-on innovation. That's what you want. That's how you generate a fantastic innovation engine. That's one of the reasons why we have been a technological powerhouse. And so, the idea that that's somehow bad and companies shouldn't do that, I don't know if that's what Colleen meant. I don't want to put any words in her mouth, but that's certainly not the advice that I would give. I would urge companies to engage in the patent system. I guess what I'm saying when it comes to PTAB is, if you look at the data, there's nothing showing that anything about PTAB makes patent rights less reliable than they were before. I mean, on the margins, maybe a little bit, some things are different, right? The Kyle Basses of the world were able to file some IPRs. I mean, he didn't win any of them, but, he was able to file some, I suppose. But, generally speaking, by and large, 90+% of situations, I haven't seen any data that shows that PTAB's had some kind of massive negative effect.
I want to talk a little bit more about the subcommittee. I think I mentioned, there's Darrell Issa as a chair, but there's 10 other GOP members. There's House members. On a practical level, for something to happen on IP issues, where does the consensus have to form? For something to happen, at least on the subcommittee level, where does the consensus have to form?
Well, generally speaking, for any significant change in IP law, and this is true of all IP law, not just patent law, there has to be consensus pretty much throughout. Now, that doesn't necessarily have to mean 100% consensus, but there needs to be a lot of consensus. I mean, people kind of forget, but the AIA, for example, when it passed, it had over 300 votes in the House. And I think it had over 90 votes or 89 votes or something like that in the Senate. I mean, that's what you need to get major IP legislation through. In the copyright world, we had the Music Modernization Act in 2018 that got 0 no votes in the House, nothing. I think it was 95-0 in the Senate. That's what you need to make it happen, because it's too easy to kill legislation in Congress in general. A single senator can hold up legislation for a long time unless, leadership has decided this is a priority for us and we're going to ram this through. And that just doesn't happen for IP bills, right? Because, that's reserved for national security bills. That's, for major, funding the government, for things like that. So an IP bill is not going to rise to that standard. So in order to make it happen, to really guarantee it happens, you need to do the work and build consensus.
But something I was curious about, if a senator or congressman wanted to say, hold up a bill and say, unless you put this thing for IP, I'm not going to vote for it. Why does something like that never happen, I guess? Because it's not really that important, or it's not the polite thing to do? Or...
Well, I don't know. I mean, every situation is different. There certainly have been times when IP bills have been included in larger legislation and passed. That certainly happened. It happened. I participated in kind of making that happen not too long ago, where we had a trio of IP bills: the Trademark Modernization Act, the Case Act, and the Felony Streaming PLSA. Put into an omnibus spending bill, if I remember right, and had those 3 pass, and that wasn't too long ago. So it can happen. I do think that, one of the things that's been happening in the House of Representatives in particular has been, the whole kind of process of passing bills and how does the sausage get made has been questioned, right? Because there have been concerns about, corruption. There have been concerns about things being slipped through and people not having enough time to read them. Do people really understand what they're voting for? There have been all sorts of concerns raised. So that whole process has been questioned in the House, and there have been reforms put into place by the Republican majority. And that has sort of kind of changed the way things are done. And so it's been, I think arguably harder to do some of that, where you're kind of slipping things in here and there. Maybe that's a good thing, right? But for things like IP, it just emphasizes again that if it's something big and there are people who care about it on both sides, both for and against, you're going to have to, there's no easy way to kind of skip all that and skip the work of building consensus. You're going to need to do the work.
Is the partisan nature of the Judiciary Committee itself, at a time like now, does that make it harder to form that kind of consensus on the subcommittee level?
So I would say no. Actually, the IP subcommittee has been, unique. I think is probably fair on the Judiciary Committee. I mean, the other subcommittees are like immigration, constitutional issues like abortion,
impeachment,
impeachment, DOJ oversight, FBI oversight. So I think in the smack in the middle of that committee, we have the IP subcommittee. I think we're the second largest subcommittee on the committee, even. But I think all but one of our hearings this year have been, very nonpartisan. I guess I would say it hasn't been really like a Republican-Democrat thing. It's just been about the issue. The one that was actually the hearing on the IP waiver, the WTO IP waiver, So often what happens in these hearings is there are typically 4 witnesses, and the majority gets to pick 3 of them, and the minority picks 1. In our hearings, generally speaking, we've kind of both sides agreed on all 4, right? There hasn't been any, they've been selected, and both sides have been like, these are fine. That was the one hearing where we did the traditional 3-in-1 model, and after the witnesses were picked, like 3 of them were like, the waiver is a terrible idea, and the minority witness was, well, yeah, it kind of is a terrible idea. Back then, we didn't know that, so it was okay. But yeah, now it's kind of terrible. I mean, that was as much kind of partisanship as we've got on the subcommittee, which I think is nice. There's been a lot of engagement from both sides, a lot of working together and cooperation with the minority on these IP issues. So, that's been nice. I'm
kind of a bit surprised to hear that, because even I thought there was a lot of even divergence within the GOP members on the IP subcommittee about these different issues. I mean, do you think there are some possible areas of cooperation where we'll see something meaningful get done this Congress?
Yeah, no, I think there's been a lot of cooperation. I mean, there certainly are differences of views about various IP issues between the members. It's not a partisan thing in the sense that it's not like Republicans think one thing and Democrats all think another. It's kind of member by member. But I think we have been able to find a lot of areas of common interest and agreement, and gotten a lot done in those areas. For example, anything to do with competition with China, I think there's been kind of broad agreement amongst Republicans, amongst Democrats, between Republicans and Democrats. There's been a lot of agreement on that and collaboration on that. AI is another one where, we're still kind of feeling out exactly where we want to be legislation-wise, but it hasn't been a partisan issue. We've all been together looking at the issues, what's affected, what are the stakes, what are the potential solutions to the problems, things like that. We had an oversight hearing of the PTO, and even though, like, for example, on the Republican side, there are members with differing views on maybe the substance of some of the things the PTO has done.
And this was the one with ANPRM proposals.
Yeah, so
for the PTAB.
Yeah, that was a fun one. So, typically the staff puts together kind of briefing materials for all the members ahead of the hearing, of course, so that they can be prepared for the hearing. I think it was like 5 days or something before the hearing, before Director Vidal was going to testify, they dropped the ANPRM.
Yeah.
I was like, okay, here you go. Have fun with that. So, yeah, that was a fun 5 days.
I've never seen, maybe I haven't watched them enough, but I don't remember ever seeing a member so engaged in an IP hearing before.
Well, to be fair, I think our subcommittee this Congress has been that engaged in every hearing. But yeah, no, I think what you saw was that, certainly I think individual members, even just on the Republican side, have different views about the substance of some of those proposals.
Yeah.
but we were able to find the things that we agreed on and that we, could have a sort of a shared view on. That was on the process followed, right? And on the importance of respecting the respective roles of Congress and administrative agency. And it was about the process. And so, even despite what differences there might be, we've been able to find things that we collaborate on.
So the Senate IP subcommittee has been pretty active in terms of releasing legislation. They released the Section 101 bill, again, a new version of that, a new bill to fix the PTAB. Do you think there's, in the short term, do you see any areas of possible cooperation within the House and with the Senate to get some legislation on related to patents done?
I do. I'm, cautiously optimistic. Now, the PERA and Prevail, I think, are two of the ones you mentioned.
Yeah.
Obviously,
is PERA the way? Or I always say PERA, but
that's what I've been calling it.
That's the Section 101. And
that's the section, right? Yeah. So for PERA, the Section 101 bill, that's been years in the making, right? That process started years ago.
You got to help them with bill naming, because yours was no free trips. The one to undo the waiver. That was a good one.
So, obviously that's been building for a while. So that was coming for a while. Prevail, I know it's got a snazzy new name. It's not exactly the same bill, but it's obviously shares a lot of history with Stronger and Strong before that. I guess Strongest wasn't the way to go. They went with a different one. Maybe the next one will be Prevailer or Prevailing more,
or maybe they will prevail. So.
Prevailing. I don't know. I think, like all major IP bills, and if either of those passed, of course, they would be major IP bills. It's going to be a lengthy process because that hard work of building consensus is going to have to be done. So, the just my personal speculation is that neither of those bills, if they become law, will look the way they look today. But what I will say is there's very good working relationships between the House and the Senate on IP issues. I know everyone there very, very well. All of us are like ex-PTOers or current PTOers for some of them. So people I've known for years, and we work together well. So there's quite a bit of discussion and cooperation about all of those things, all of those issues. I do hope that we're going to have some patent bills in those areas, maybe some other areas as well. But it's just hard to say because it's going to, we're going to have to see where the friction is, which stakeholders are going to object, and what changes are or are not going to be necessary to kind of get them on side, those types of things. And it's just going to be a long process.
Correct if I'm wrong, I guess, but my sense is at least you feel there's an openness on the House side, work together on companion legislation to figure out a compromise.
Yeah, absolutely. I mean, before Prevail was even introduced, there were conversations happening with the Senate, between the Senate and the House, about PTAB reform. I think Chairman Issa said, multiple times that he agrees that PTAB reform is a good idea, that we need to look at that. I think the way he put it is the idea that Congress, when it passed the AIA, got PTAB exactly right on the first try. I mean, Congress gets nothing right on the first try, or maybe even the 10th try. So, that certainly everyone can agree that improvements can be made. The scope of those agreements, I'm sure, the scope of those improvements, that's going to be a hot topic of debate, of course. But, I think we can all agree improvements can be made. We've had, promising discussions about some of that, and we're going to continue that. And I can't promise a particular time frame. AIA took like going on 10 years for it to happen. I hope it won't be that long, but I'm reasonably hopeful that something will get done.
But chances are not this Congress.
I wouldn't necessarily say that. I'm not really a gambling guy, so I wouldn't put money on it either way. But I wouldn't bet against it. I wouldn't bet for it maybe either, but I wouldn't bet against it.
I bet people who want those bills passed would be very happy to hear that assessment.
I mean the way to think about it is not really about is it going to get past this Congress or not. I think the way to think about it is substantial progress made this Congress or not.
Yeah.
Right. So if at the end of this Congress, both the House and the Senate have PTAB reform bills, neither of them gets passed, but they were introduced, they were changed, and they got substantially closer together in terms of what's in them. I think that's great progress. That shows it's headed in the right direction, and it's got a good chance of eventually happening.
And what helps make that progress?
I think one of the big things, something that I hope to see just personally, is for all the stakeholders who care about this, and that's a lot of stakeholders, right? Because this is important to a huge swath of the American economy and to Americans in general, is that they get involved early, they give honest feedback early, that they're constructive. Like no one's like, you do this over my dead body and, I'm going to hold the sausage. But instead everyone's like, okay, this, I can't live with this.
Yeah.
I can live with this if I get this. Like some kind of constructive feedback.
Right.
And everyone does that early and no one kind of like keeps their powder dry until it gets to a certain process and then like a certain point in the process and then, does a drive-by to kill it or something like that.
And there will be attempts.
Yeah, no, I'm realistic. Obviously, some of that's going to happen.
Yeah.
But if as many like important stakeholders as possible engage in the process, so that at the end of the day, it really is a consensus product that a huge amount of people on both sides of the debate have engaged in good faith, then that's got a real good chance.
We're not going to expect the CLU or EFF to endorse any Section 101 fixes.
And I just want to clarify, consensus does not mean everyone agrees.
Yeah, no, exactly.
Just means critical mass.
No, I was echoing that. That's the point I was trying to make. So
yeah.
Clarifying. At the IP Watchdog Live panel, which I moderated, I said, we discussed the Patent Eligibility Restoration Act.
Yeah.
And you mentioned that there might be a companion House bill. Anything new on that? What do you think we should expect on that front?
I still think, I guess I haven't checked recently if they've introduced it or not. If and when it's introduced, and I think it'll be, I think, identical, is my understanding. So if it hasn't already happened, I think it will happen at some point.
Is that a sign of momentum at that point?
In and of itself, I wouldn't say that's a sign of momentum. It's not like super hard to get something introduced in both the House and Senate.
Yeah.
I think, momentum would be if, stakeholders get involved, there are negotiations, live negotiations going on, Bill's language gets changed or, there's some kind of committee process, whether it's like roundtables or hearings or something. And, people see the bill progressing, changing, strengthening, getting more people behind it or having critics drop out because they're no longer critics, things like that. I mean, that's what you want to see.
Do you think that what it will take to fix Section 101 was to find a way to bridge the gap? From what I understand, Section 101 plus something else that maybe those who don't want to fix Section 101 will take. And on the panel, there was somebody who doesn't think there should be a section for 101. And I said, is there anything you want? And he said, no. What do you envision that's something else being, or I guess options or possibilities?
Well, I don't want to speculate on that. I mean, with how chaotic patent law has gotten, we're sort of in this unique time where everyone who's got some skin in the game has something they'd like to see changed. Right? Something has not gone right for everybody. And so, I think there is this kind of environment where things can be kind of traded because everyone wants something. So I don't know what that would be for Section 101. And I said that about Section 101 mainly because, it's been so hard to find consensus on that. And it's kind of gotten to a point where, the folks that want reform and the folks who don't want reform, they're kind of like, they're not really engaging in a constructive dialogue anymore, in the sense that, no one's kind of putting forward new ideas, trying to think outside the box, seeing what they could trade. It's just like, this is what I think, this is what I think, we're not in the same place. And maybe the thing to do is to kind of find something else outside of the debate that's been going on, some new element to maybe kind of goose that process. And that could be, some other thing that detractors want that could be negotiated together with that.
Putting Section 101 aside, I mean, what is the big pain point that you think is on the side that, might think that patents, there's still a patent troll problem, or whatever way you want to frame that? I guess, what is the patent point, any big pain points on the other side?
Well, I mean, I don't want to speak for them.
Yeah.
I've certainly,
from what you're hearing, yeah.
Yeah, I've certainly heard people come in to talk about things like, third-party litigation funding.
Okay.
And how that's a scourge, a blight on humanity. I've heard, they've talked about that. They've certainly talked about things like discretionary denials at PTAB and FinTIV and those types of things. Things having to do with standard essential patents. Just off the top of my head, those are three just popped into my head just now. So there certainly are things. No one is coming in and telling me the patent system's perfect, touch nothing. No one is doing that right now. And I think in the past, candidly, there were people who were kind of saying that. Maybe they didn't believe it, but they were like, this is pretty good. I don't think anyone thinks that right now.
Do nothing. Well, that's, I guess, heartening to hear. You mentioned that you clerked on the Federal Circuit. The big news with that is the rest of the Federal Circuit suspending Judge Pauline Newman. Any thoughts about what's going on there?
I care a lot about the Federal Circuit as an institution. Obviously, I work there. I care a lot about a lot of the people there. I know people who still work there. And I think it's really sad in the sense that, this has not been very good for the court as an institution in terms of its image, public trust in this institution, its ability for the judges to kind of get on without the distraction of this. I think that's been very unfortunate. I don't want to comment too much about it because this actually is an issue that the subcommittee has engaged in a little bit, and I'm not really at liberty to talk about the details of that. But I think, everyone involved would probably agree that this hasn't been great for the court as an institution, and that's very unfortunate.
You mentioned a few ways people have been able to make positive impressions on you. You mentioned the importance of consensus in passing bills. Any other advice for those trying to impact the direction of patent policy in Congress?
I actually just had ethics training, and I was told I can't give people advice on how to better lobby Congress. So I'm not going. I can't do that apparently, and I'm not going to do that.
That's weird. I guess you would think you'd want to encourage people to.
What I will say is that
to help you do your job in a better way.
I'll just say personally, what I really appreciate from people who come to see me are people who maybe they themselves are not knowledgeable about what they're talking about, but they bring someone who is, right? There are, and I'm not going to name any names, but there's certainly lobbyists who come. They've been hired to get some point across. They don't know anything about it, right? They're hired because they know people and they can get access to people, but they don't know anything about it. And so they come in, they talk to me. I ask them surface level questions to dig an inch deep, and they're like, I'll get back to you on that. And I'm just like, okay, why did I have this meeting? So a staffer's time, any staffer's time, is very valuable because so many people want to meet with them all the time that there's, time is such a huge commodity for a staffer. And so I think people who come in respecting that, and it sounds obvious, but it's amazing how often that doesn't happen. So I would say that's something that I personally appreciate. Like if you're going to come in to talk about a bill that you want to see introduced or something like that, like actually having the bill or sending the bill in advance seems obvious, but you'd be shocked just how many people don't do that, right? And you're like, that's great. I don't know anything about this bill. I haven't read this bill. It's just, a waste of time, right?
But do you think it's part of it that IP issues are maybe more unfamiliar, more complex to somebody who's never thought about it before, that somebody who can lobby on healthcare and immigration and so forth?
Yeah, I mean, I have sympathy for lobbyists in the IP space because aside from me, and literally I can count it on one hand, right? A few other people, nobody else on the Hill has any IP background at all, right? Even the ones that deal with IP issues. So, an IP lobbyist has to come in prepared to talk to those people, as well as, the five of us who have a long background in IP. So, and talking about explaining what IP is like and how it works can be very difficult. So I totally get that challenge. But before I got to Congress, I really thought that lobbyists, hopefully none of them get too mad at me. I thought that lobbyists were like a cancer on society, right? I mean, they're like these unnecessary middlemen who like come in and they peddle an influence, and God, they're terrible. But what I'm realizing is like public policy, like policy professionals, lobbyists who really do the job well are like very, very important to the system, right? I mean, they explain things to people to get people information that they need. They talk to the right people, make sure the right people get connected. If I have follow-up questions, to make sure those questions get answered. If I need something in order to do my job, they're able to provide that. I mean, they're a great resource, the ones that are good. It's a minority of them, frankly. They're good ones. They're not that many of them, but I really appreciate it. So yeah, no, I mean, finding a good lobbyist, I think, can only help. If you're going to be trying to affect policy, on anything.
If you're going to try to impact patent policy, should you just be focused on those handful of people who are IP policy, or should you be going office to office and seeing like, well, maybe somebody's going to embrace our issue and then harass you?
It kind of depends on where it is in the process, but I would say that certainly to start and throughout the process, the people that spend all their time on IP policy on the Hill are I mean, it's kind of self-serving, but I mean, they're the most important, right? Because they're going to control, does the process get started? How does it unfold, et cetera? Now, eventually, it's going to be important to widen that circle. Yeah. But until you get there, I mean, those people are very, very important. You need to get those people on side, at least one of them. And when I say those people, I mean, what I really mean is like the chairman of the House and Senate Judiciary committees, the ranking member of those committees, the IP subcommittee ranking member and chairman, like the members. And for any member, obviously the staff they listen to is important, but really I'm talking about the members. If you can get one of them on side, that is immensely helpful, right? Because everything's going to go through those people. No matter what it is, where it comes from, it always goes through those people. Yeah. And if any of them decides, like, I really want this to not happen, they can probably make it not happen. But eventually, assuming it's gotten through those people and they're cool with it, they're not enough, right? You need the rest of the committee and then the rest of the House and the Senate. But yeah, certainly I think focusing on those people, certainly to start, is the way to go.
So it's not like you're going to get a bunch of 12 members of the House pressure the subcommittee chair into...
I mean, it's not like it can't happen, but when it comes to IP, to find someone who's not on the IP subcommittee who really cares a lot about IP is pretty rare.
Any final thoughts or anything you could share about... It seems like you've learned a lot since you've been on the Hill.
Yeah.
You want to share what other people should know about how it works?
I don't know. I mean that actually has been the best part of working on the Hill. Is I've learned so much, just about not only about Congress and how it works and how laws are passed and how the sausage gets made and all that, but also about IP. I knew essentially nothing about. I'm a little ashamed to say it, but I knew essentially nothing about copyright law, trademark law, trade secret law before I got to Congress. I've learned a ton about those things, and that working on the Hill, you don't get paid very much. I think that's not a secret. But the benefit is that you learn. You're in a position to learn a ton, and it's such a rewarding job in that way. So stuff I could share. I mean, the thing that I share the most, that I think is the most surprising to people, and you're going to have heard this before, but maybe some of your listeners haven't. The thing that I think most people are confused by is like, why do we need consensus when it comes to IP? Because when you look at Congress or politics in general, it doesn't seem like you need consensus for anything else, right? Nothing happens with consensus, essentially. Why is IP so different? And what I try to explain to people is, unsurprisingly, the thing that matters most to a politician is, how do I get reelected, right? Or get elected to my next thing or something, right? It's keeping voters happy. In a way, that's the way we want it, right? We want them accountable to the electorate, right? So that's the way we want it. It's democracy. But that's what's important to them. And IP is important to essentially no voters. Voters don't care. They don't know what it is. They don't care about it. No one votes on the basis of IP policy. No one is going to a town hall with a congressman, be like, you better tell me, what you think about Section 101 reform. And based on your answer, that's how I'm going to vote. Like, essentially nobody does that, right? So as a result, no congressman's going to be like, I'm going to use all my political capital and stake my reputation on pushing through some damaging IP policy that some people out there hate. So what that means is, it's really easy to kill a piece of legislation, because you just find some people who are gonna. All you need to do is find a couple of people, a couple of members who are going to kill it for you, and no one is going to say, "Well, I don't care about that. I'm going to drive it through anyway," because it just doesn't resonate with. It's not going to get them reelected. And so what tends to happen is that you need broad consensus, where everyone's just like, hey, pretty much everyone seems to be for this. I know Bob and Jill aren't, but everybody else is. So, hey, I'll go along with this. That's kind of what you need.
Well, and on those words of wisdom, John, thank you so much for taking your valuable time to come on Clause 8.
Oh, hey, thanks. It's been fun. Thanks for having me.
Thank you for listening to Clause 8, the voice of IP. If you enjoyed this episode, please share it with others and leave us a 5-star rating in your favorite podcatcher. For more information, visit voiceofip.com. And don't forget to check out our full archive of previous episodes. Clause 8 is a brouhaha audio production. Thanks for listening, and we'll see you next time.